There have been concerns over the depleting number of justices on the bench of the Supreme Court in Nigeria. In a swift reaction to this, some senior lawyers have called for the immediate appointment of judges to fill the vacant positions. By law, the Apex Court is supposed to be composed of 21 justices, but as at the last count, there are only 11 justices on the court, including the Chief Justice of Nigeria, Justice Olukayode Ariwola. At the beginning of last year, there were 17 justices on the bench of the Apex Court. That number was trimmed down between May 2022 and September 2023 by way of voluntary retirement or death. Let's now turn to a former Attorney General of the Federation and Minister of Justice, Michael Aondoakaa, for a conversation on the shortage of justices at the Supreme Court and the impact on the dispensation of justice. He will also speak on the review of the Presidential Election Petition Tribunal judgment in Atiku and Obi's petitions against Tinubu's victory. Good afternoon and good to have you on Arise News. Thank you so much for joining us on the program. Well,
good afternoon.
Good afternoon.
Thank you.
So what are your thoughts on the depleting number of justices on the bench of the Supreme Court? What impact is this having on dispensation of justice in Nigeria?
Seriously, it's having a negative impact. But I think steps have been taken now to speed up the process. We are just coming back from the Court of Appeal legal year, and we had the good news that the steps are being taken from the Attorney General, Fagbemi, to fill up the vacancies. It's a matter of concern because in the Court of Appeal, we were made to understand about 20% of the justices of the justices of the Court of Appeal will be off before the end of this year. Already about 18 justices of the Court of Appeal have retired. Vacancies existed. And now they appointed 9, but they're in the process of appointing more justices of the Court of Appeal and the 17 justices of the Supreme Court. Because the workload on the justices of the Supreme Court is something else. The people have courage and they need to appoint more justices to that court. I think the government is taking proactive steps to address the situation.
And we're hoping that it actually gets moved very soon, that those 8 or additional judges are appointed in order to help with the caseload. But there's some that recommend amendment to the Constitution concerning making them increase the number of justices currently serving to 30 plus. Do you think that this is another avenue that could be explored?
Well, that is part of it, but I think the most important thing is to allow certain matters not to reach the Supreme Court. It's matters of constitutional matters, matters of serious concern, which involves very serious legal issues of law that ought to go to the Supreme Court. But now you see, even ordinary land matters that sometimes start from area courts ends up to the Supreme Court. So we need to have certain interlocutory applications up to stop at the Court of Appeal. So this need on ordinary issues of stay or execution sometimes drags on to the Supreme Court. So there must be some way to structure the Supreme Court in such a way that real legal issues goes to the Supreme Court. Of course, there should be areas we can touch to ensure that really the Supreme Court is not overburdened on frivolous matters. I think we also have on the side of the lawyers themselves, we know lawyers, not every appeal we should aim to go to the Supreme Court. Some are really not worth going to the Supreme Court. We should try to look at alternative dispute resolutions. Some matters can be settled that way without reaching the Supreme Court. I think it's not really the number of judges. If we increase the number of judges, but cases continue to go to the Supreme Court at the rate at which it's going, you know, there's so much awareness and litigation now. Before a person goes to, by the time he reaches the High Court, he's tired. He say no. But now, everybody who started litigation, he will boast that I'm pursuing the matter until he reaches the Supreme Court. So that's the dilemma. Even if we increase the number to 36, but still, if we don't control the number of cases that go to Supreme Court, we're still going to have the same problem. So my concern is to look at the Constitution. Other issues can go to Supreme Court, but only leave for the Supreme Court. That would be very desirable. And leave can be held by a single justice of the Supreme Court, or to grant leave or not. That will be, we look at those areas, and that will be much better.
Well, what about political cases? The Chief Justice of Nigeria, Justice Kayode Ariwoola, believes the bench is overlabored and political cases are taking a monumental toll on them. So would having maybe a special court set up for election disputes help resolve this matter? Or do you think it's something that can also be handled at the level of the appeal court?
Political awareness is going, but at a point in time, people will also try to accept decisions by not going to court. It's not a matter of establishing cases, not a matter of establishing more special courts. It will still end up. Those special courts may not, you not create a particular court and say it doesn't have an appeal, an appellate, his decision cannot be appealed again to a higher court. That will create anarchy. So even if you create a special court, you will expect the special court appeals to go to court of appeal and to Supreme Court. Because the special court cannot just be created and make it a court that cannot be appealable. So this is the problem. The problem may not necessarily mean special courts, but looking at the way we should learn to accept some defeats, where you know that the electoral process was substantially in compliance, but the system will evolve itself in a better way. I'm very optimistic that the system will grow. Electoral culture is still growing, it will grow, and then the people may not be going to court much, and then things will be much better. It's not a matter of establishing more courts, however.
Would it be more of a matter of establishing jurisdiction over what kind of cases the Supreme Court adjudicates? And also, what do you think about the retirement age? Maybe raising that a little bit just so that some of the serving members of the court could have a little more time. What's your opinion?
Retirement judges should be raised again, or the Supreme Court justice should be raised again. I think it came out when I was Attorney General, but we looked at our system. In fact, it first came up when I was Attorney General that the justice of the Supreme Court should retire at the age of 80. We felt it's okay, but we looked at the head system. We looked at the manual manner in which they conduct the businesses of the court in Nigeria. And we felt that it's more desirable for them to retire at 70 and still have some few useful age to attend to their family. We did not include that in the amendment of the Constitution. And I think even now, if you look at it from that perspective, if we have modernized our court, we're not doing handwriting, and we're not doing all these things, you can also say, okay, they can stay out to 80 years. But they are doing manual writing, and it's very tedious for you to have moved from High Court, Court of Appeal to Supreme Court, doing manual writing to expect you to live out to 80 years. I think it may not be, but I don't know how they feel about it. But to me, when I was a General General, I felt it was not proper. I also look at the mortality, the rate, the date, and I felt that if you say people should retire 80, how would the younger ones ever reach the Supreme Court? But that was my own perception as Attorney General at that time. I felt that as the 70 years, there should be space for the others to also grow and reach the Supreme Court. That was my desire. And up to now, I don't think I've changed my position that the retirement age should still remain at 70, except life expectancy has moved up in Nigeria and medical facilities have moved out, and then we have totally embraced ICT in our technology in court proceeding. Then we can think about that. But for now, I think it will not be hard for them, for the learned justices of the Supreme Court, to aspire to go to 80 years.
Now,
What should be most important is not Can you allow me to finish? What
Please
is
go
most
ahead.
important is not when they retire, served 80 years, but after that, their welfare should be more taken care of so that they can now do justice without fear that when I leave Supreme Court, what happens? Will Nigeria abandon me? Most of the Supreme Court judges are left the court and they're in complete penury. Their pension is not coming as desirable. So there must be an enhanced pension scheme for justices of Supreme Court, or indeed the Court of Appeal and High Court. When they leave the court, they should enjoy the wages of their work when they were sitting as an impartial judicial officer.
Now, in June of this year, we heard that the process had begun on appointing more judges to the Supreme Court bench, but so far we've not heard of any appointment being made. So I'm just wondering if you can give us an idea of what the process is like and how long it might actually take to appoint these judges. Then also, is it only judges from the appeal court that are to be elevated, or is it possible that lawyers can be appointed directly from the bar to the Supreme Court bench?
There has been that move, and unfortunately, we have not been lucky from the bar to have. I think during Justice Onogan, an appointment, Chief Justice Onogan, GCON, he actually made the move to allow private lawyers, senior advocates, to aspire, professors of law to aspire to be appointed justice of the Supreme Court. And then also, I think Justice Stanko also, it was on the table, but unfortunately, when the list came out, unfortunately, some aspired to be justice of the Court of Appeal, but unfortunately, we are not being lucky to be shortlisted. If you look at the Constitution, it does not say you must be a judge to be a justice of the Court of Appeal, or a judge of the High Court, or even a justice of the Supreme Court. It says you should be a lawyer, Supreme Court of 15 years standing. But you see, the process have been, as a matter of policy, as being High Court to Court of Appeal to Supreme Court. But one day we may be lucky, as before. I think there's a time a lawyer, Namani, who was an Attorney General, moved from there, from the private. Though he was in the Attorney General, was an official from there straight to the Supreme Court. Time will come again for, and of course, I think Elias, the then Chief Justice of the Federation, moved from Dean of the Faculty of Law straight to Supreme Court. We're aspiring for that. We're hopeful that one day our people keep applying, and one day we'll be lucky to be shortlisted. It's there on the table. We apply, but unfortunately, we are not being yet shortlisted. So I hope one day the wisdom may prevail and they will allow professors of law, lawyers of great repute to aspire to get to Supreme Court or even Court of Appeal.
Well, we hope so too. And in this brave new world of artificial intelligence, chat GPT, predictive text, and even, I dare say, robots, what is the Supreme Court doing in order to embrace technology? I was a little bit shocked to hear that they're still writing out scripts, and this could cause the delays in some of the adjudication of cases, which is what you were saying a little bit earlier, coupled with the age of some of our judges. What is the Supreme Court doing to embrace technology? Is that a discussion that's being held? And if the technology isn't being embraced, what are the reasons?
Yeah, technology has been embraced by the Supreme Court. They have started hearing notices now. It's not manual. A lot of other things are going. I think the next stage is the filing of processes. And of course, but the issue is not what is the Supreme Court doing. It's what is the National Assembly doing to enhance the budgetary provision for that. It should not even be the Supreme Court justices themselves. The Supreme Court justices are in a tight position. They can't go and argue for themselves. They can't defend their budget. They can't do everything. Is either the executive or the National Assembly. So let's ask this question back. What is the executive doing in the time of this when the global gone internet? What are they doing to enhance our courts? Because the Supreme Court don't renovate their courts themselves. The infrastructure is being given, even though there's judicial autonomy. I don't think it's being fully implemented as envisaged in the Constitution. So they still go to the National Assembly for their budgetary allocation, so for capital expenses. So let's ask ourselves, what are we doing to assist the Supreme Court to go digital, full-blown digital, where the judges of the Supreme Court will not need, or indeed judges of Superior Court will not need to go start writing manually. That question should be the other way around. And I expect that the current president, who is highly exposed, will ensure that, and the president Attorney General will pursue vigorously to ensure that our courts are fully optimized. Not only the Supreme Court, from High Court to Supreme Court. That is the desire. That ought to be the desire.
So how important is regional balance in making this appointment of Supreme Court justices? We understand that the appointments are meant to ensure regional spread, but in practice, is that what actually happens most times? And what can be done to actually ensure that there's regional balance in this appointment?
I think the current Chief Justice has ensured regional balance. In the advertisement, he clearly stated these are the vacancies for this area. These are the vacancies for this area. The Chief Justice of the Federation, he has already done the regional balance. He did not mince words. I said, so vacancies exist. I am from North Central, and he said North Central have 3 vacancies. So you could see he has already done the regional balance. Those people who are aspiring from those areas will apply. It's done. He has been very fair, and I think all the regionals, it depends on who and who has retired from that area. He has made sure that there's a spread in line with the federal capital. I think North Central has the highest because they have not been fortunate to have a replacement of people who retired from their Justice Echo. And so they have been able to give them up to 3 allocations. The Chief Justice does not come from North Central, but in fairness, North Central has the highest.
All right. I want to change the discussion just a little bit to move to the PEPC judgments and the results afterwards, and of course the fact that they're going to the Supreme Court with their cases. Also want to discuss INEC. From a layman's perspective, watching what was going on back and forth within the courts, it seems that one major player was not included, and that is the umpire, the umbrella body, INEC. It seemed like there was no burden of responsibility or little burden of responsibility put on them to prove either way, except, of course, from the individuals who asked for certain documents from them. But what burden of responsibility should INEC be facing, as it seems that the burden of responsibility is falling on the wrong side, in my opinion? What burden of responsibility do they have? Should they have?
Well, thank you very much for giving me the opportunity to comment. First, since the judgment was delivered, I have not given any press conference. I have not talked to the press about it because I was looking at the documents. But I am afraid I cannot go deep to answer your question in the sense that I don't know the kind of evidence until the record is completely prepared, and I'll be able to look at the evidence presented by the petitioners. The cardinal principle of administration of justice in civil proceedings, even though election petitions are signatories, is that who alleges must prove. So if you say you have social witnesses, you must bring witnesses that can prove. Though there's one area, I think, which is agitating your mind, the issue of INEC releasing document timeshortly. Of course, it is going to Supreme Court, and Supreme Court will look at that. Election petitions have to be filed within 21 days. INEC normally is a defender, is an adversary. Therefore, how will you go to your adversary and ask him to give you documents when he's not willing? And if you say he should make a statement, he's not willing, how will you wait until after 21 days? But that matter will be resolved in the Supreme Court. And it is expected that But there was a judgment of the Court of Appeal. The Judge of Appeal felt, I am at loss, just like you are. The judgment of the Court of Appeal. There was a judgment of the Court of Appeal before that said, look, if INEC has documents after the filing and their subpoena to produce the document and testify, their written statement can be accepted. It was a judgment of the Court of Appeal, another division. But this was a full division of the full panel of the Court of Appeal heard. I have not looked at it very well, but I'm hearing that they said such statement will not be admissible because they were made after the petition has been filed. What I'm just wondering, like you are wondering, if I'm to file documents and I have 21 days and INEC is in custody of the documents and I need to subpoena INEC to come, then if I wait until they come and the defender, will a defendant readily admit to give me a statement to back my petition before I file? That's some area, but the Supreme Court will look at those things. That's why we have the Supreme Court. I think one son spoke on channel, not your television. And also, that is one gray area we think we can look at it. So that when it comes to production of documents, there should be a window at which, since the documents is in adversary custody, and we subpoena the adversary custody to produce it, those statements at that time could be accepted because you were not in the custody of the time document, but you have given notice that you compile them to bring it. And that should suffice. But you still have to go to Supreme Court to have a look at it.
Former Attorney General of the Federation.
I don't look at you.
Former Attorney General of the Federation and Minister of Justice, Michael Aondoakaa, thank you so much for joining us on Newsday.